Ending a marriage is no walk in the park, and the initial steps can be a bit of a puzzle. If you're thinking about getting a divorce in Colorado, the first thing to do is grasp the latest rules and the steps. This video takes a deep dive into the very first, not to ignore step to start your divorce in Colorado. By watching this video from start to end, you'll gain the knowledge and confidence you need to take those next steps with a clear mind. What's going on, family? It's Bobby Friel with the Just Living Realty Group. Please take notes during the next few minutes, and thank you for visiting with me today. I've gone through a divorce myself, and I've helped dozens of clients through this very same situation. On this channel, we talk about tough topics like divorce in Colorado real estate and mortgage. Before we head off to review the initial steps for getting a divorce in Colorado, please head down and like this video. And if you're new here, make sure you're subscribed and hit the bell click for notifications when new videos are uploaded. And we do get so many phone calls, texts, and emails every single day from people just like you needing real estate and mortgage guidance while going through a divorce. So if you need our help, simply reach out. There should be a link in the description or the top pinned comment to book a meeting. Again, before getting into the initial step, remember that Colorado has a residency requirement. At least one spouse must have been a Colorado resident for at least 91 days before filing for divorce. This establishes the state's legal jurisdiction over your case, so make sure you meet this requirement before proceeding. The initial step is filing a petition for dissolution of marriage. The first step in initiating your Colorado divorce is to file a petition for dissolution of marriage. This document formally informs the court of your intention to dissolve the marriage and sets the wheels in motion. But what's included in the petition? Personal information, names, addresses, dates of birth, both spouses, marriage details, date, location of marriage, length of marriage. Grounds for divorce. Colorado is a no-fault state, meaning you no longer need to prove marital fault to dissolve the marriage. You can simply state the marriage is irrevocably broken. Children. If you have children, the petition will address child custody, child support, and visitation agreements. Property and debt. The petition will outline your proposed division of marital property and the debt. So names, addresses, and dates of birth for both partners are needed for the divorce petition. Details about the marriage, such as date and location, plus the duration of the union, are essential. In Colorado, divorces can be filed on no-fault basis, meaning that you don't need to prove marital fault, but you can simply state the marriage is irrevocably broken. If there are children involved, the petition will cover child custody, support, and visitation plans. The division of marital property and debts will be outlined, suggesting a fair split. Prayer of relief section summarizes your request with the court, including the dissolution of the marriage, custody decision, and property division. Filing the petition. You start with filing the petition with the district court in the county where you and your spouse reside. You can file online in some counties that offer online filing for a quicker and more convenient process. File in person. Visit the clerk of court's office and request assistance with filing the petition. Here in Eagle County, where I filed, they were very, very helpful. Although I did do the filing myself without the need of an attorney, it did take me 2 different tries to get the filing process corrected, but they were very helpful in doing so. That said, you can hire an attorney. An attorney can definitely help you complete the petition accurately and handle the filing process. Again, I did it myself, and it really didn't take me too much time to get it right. Filing your petition for dissolution of marriage isn't the only thing you need to know, but there are a couple additional hoops to jump through before the legal ball officially gets rolling. Let's break down the costs and the process of notifying your spouse so that you know exactly what to expect. Filing fees. Think of these as entrance fees to the legal system. In Colorado, the current filing fee for the divorce petition is $230, but that's not all. Depending on your situation, you might encounter additional fees like about $116 if your spouse files a response to your petition, $223 if you need to add another party to the case like an intervener, and court costs, which vary by county, so do some digging to get an accurate estimate. Service the process. Now, this fancy term simply means letting your spouse know that you filed for divorce. They have the right to be informed and respond to the petition. There are 2 main ways to do this. Process server. These professionals are like legal messengers. They'll physically hand your spouse the petition and the summons to appear in court. Expect to pay around $50 to $70 for their services. Certified mail. This is obviously a cheaper option. This only costs about $10 to $20, but you'll send the petition and summons via certified mail with a return receipt requested. This proves your spouse received the documents, even if they choose not to sign for them. Another thing to know is you need to save your receipts. You might need them later for reimbursement purposes. Secondly, check your county website. Some counties offer free payment options or reduce fees for those with financial hardship. Plus, ask your attorney if you're going to have one. They can handle the filing and service of process for you, taking the burden off your shoulders. While the initial cost may seem daunting, remember that most of these fees are a one-time expense, and investing in a smooth legal process can save you headaches and financial trouble down the road. Alternatives to filing that petition. In some cases, alternative dispute resolution methods like mediation or collaborative divorce can also be helpful. These processes focus on reaching agreements outside of the court, potentially saving time and costs, but only if there's any chances of it. So once you've kicked off the divorce process by filing and serving the petition, it unfolds like a well-orchestrated, albeit emotional dance. Each step builds on the last, guiding you towards the final act, the decree of dissolution. First off, it's time to spill the bean about your finances. Both of you will lay bare all of your financial details, sharing bank statements, investments, and even that old gym membership you keep forgetting to cancel. This financial transparency ensures everything from cozy homes to hefty credit card bills is divided fairly. It's like a financial dance where openness is key to splitting assets smoothly. If you have kids, their well-being becomes the star of the show. This is where the magic of creating a parenting plan comes in. Custody arrangements, visitation schedules, and child support, they all get woven into a roadmap for raising your kids after the split. You're building a sturdy bridge across a new emotional landscape, making sure your children's needs are met with love and consistency. Then comes the delicate dance of dividing property. Houses, cars, furniture, even that china set from grandma, each item gets carefully assessed and allocated. Negotiation is the preferred partner here, but if talks get stormy, the courts might step in. Remember, compromise is key to a smooth dance through this phase. Finally, the grand finale, the decree of dissolution. The official document declares your marriage is officially over, putting the final stamp on your emotional roller coaster ride. But reaching this stage isn't always a sprint. Some divorces move quickly, while others take time, especially if disagreements linger. Be patient, keep communication open as long as your heart allows, and trust that your attorney will guide you through the legal maze. The legal process might have its tricky steps, but you're not alone. Resources like mediation, support groups, legal aid, and therapists are there for you. Surround yourself with understanding partners who can get you through the emotional rapids. And if you have questions about your mortgage or your real estate assets before they're split, or how a refinance to cash out one party to another can help before you sell your marital home, we are happy to help you. I've gone through this myself, as mentioned. Please reach out by text, email, phone. Better yet, get to the front of the line and you can book in a one-on-one consultation so that we can put our best foot forward and address any questions that you have. The link is in the description. Take care.